Hello, everyone. Welcome to the lecture for Legal Studies Units 3 and 4, as well as the ATAR Notes April lecture series. My name is Sunny. I'm really excited to be delivering this lecture to you all today, and I hope that you find it really useful. We'll be doing a detailed breakdown of Unit 3 Area of Study 2 for legal studies in preparation for what you're going to be studying in your next term at school, as well as some important tips and tricks for the subject, including answering questions in legal studies and how to collect all the marks, which I hope everyone finds really helpful. You can see on these slides some of the resources ATAR Notes has to offer, which can be really handy as well if you want some additional support and help with your study. Let's jump right into the lecture. So I'll begin by introducing myself first. As I mentioned, my name is Sunny. I completed my VCE in 2021 with an ATAR of 96.70. My highest study score was in legal studies, where I received a 47 study score. And I also did well in my other subjects, including English, literature, English language, general maths, and psychology. And I'm currently studying a Bachelor of Paramedicine at Monash University, and I'm in the last year of my degree. So you can follow along through the bottom bar. As you can see, first we'll have a chat about the importance of the study design for legal studies. Then we'll get into most of our content for the session, looking at Unit 3, Area of Study 2, the civil justice system, as well as answering questions in legal studies and finishing off with some study tips. So first, let's have a chat about the study design. So I can't stress the importance of how important it is to actually work with the study design. You should have it printed out and highlighted and annotated to tick off key knowledge dot points, key skills dot points, because the legal study design makes sure that you have direction in terms of what you're studying. So you don't go and study above and beyond. There's way too much information in legal studies textbooks, and it's unrealistic to know everything. So it literally tells you what kind of questions you can get on what topics on the exam. So you need to be working really closely with it to make sure that you focus your studies so you can come out with a good study score by the end of the year. So this is really important every time you start a new area of study as well, having a close read. And the new study design as of this year, 2024 to 2028, it hasn't changed much from the old study design, meaning that when you work with practice exams, old exams, most of the questions are still absolutely the same as what you could be getting at the moment on the exam with the new study design. So you have, all the way from 2019 to 2023 exams to work with that are mostly up to date with your new study design, and you should be consolidating each area of study in the form of finding practice exam questions, doing them, attempting them under time conditions, and marking yourself based on the examiner's reports provided with suggestions for your answers and notes about how the questions were marked that year. And that's really important. So as I said, the key knowledge dot points, they tell you exactly what you need to know for the exam. They tell you very specifically what you can be assessed on. And it's much more specific and tunes out a lot of the stuff that's, in your textbook, all of that additional information that you don't need to memorize. These are the things that you do need to memorize and the concept that you do need to memorize. And the key skills dot points tell you everything you need to be able to do with that knowledge. So they tell you what kinds of questions you can get, and they even include task words of the questions that you can get. So it acts as a big hints for students. What you will notice is some of them repeat, so you're always expected to be able to define and use any of the legal terminology that you're learning about. And it always says discuss, interpret, analyze legal principles and information. So it always says that you need to be able to apply and answer questions that have stimulus materials by making use of stimulus material and actually incorporating it into your response. So if you're giving strengths and weaknesses for a process, some of the strengths and weaknesses that you'll give if you have a stimulus material will be directly related to that stimulus material. So stem directly from your stimulus material. It can't just be in the form of mentioning the names of the people that are in the scenario in the stimulus material. That's not what it means to incorporate the stimulus material. You need to give specific points based on what you've read and what is in there. So those are a couple of things to pay attention to and really, really practice. And I feel like a big weakness for students is using a stimulus. That's often done poorly in the subject. Work closely with exam reports and past VCA exams. Now, a lot of schools are really great in the sense that legal studies teachers, whenever you're learning anything, some of the homework tasks that they give you and tasks that they do in school is working with past exam questions, going through them together, writing a response, breaking it down, marking it. If you don't already have, if you don't have a legal studies teacher that does that, or that's not the case in your class, you must go out of your way to make sure that you are doing this yourself if you want to do well, because there is usually a big discrepancy between how school SAC questions are written and then the actual exam material. The questions are not really the same. And if you don't continuously work with past exams, then, by the end of the year, when you're prepping for exams, you won't have had enough repeated exposure to past exams to know your way around them, know how to navigate them. As soon as you read a question, know what you need to answer. So really important that you work with past exams and you can use exam reports, find the specific question that you've done and mark yourself based on the feedback, suggested points, and the exemplar response that will be provided. So do this, try to do at least a past exam question every single week. Doesn't take very long. So do it under time conditions and try to do your best. They're often harder than what you've got in school as well, a lot of the questions. Okay, so as I mentioned, there's an examination report produced for every single year, and they are the best for preparing yourself for the exam, learning how to answer questions. They're absolutely the best resource, and it tells you directly what is expected from the state rather than, some differences that might be present in how schools and teachers teach legal studies, but it tells you directly what the expectations are for the state. And this is what you should be following, even if there are some discrepancies to what you do in school. This is how you're assessed. So they're really, really useful. Some of the things they've got mark averages and tips on how to get full marks. So we can see in this example, the question, students could score up to 8 marks on this question. It gives the average for the entire cohort that year that did the exam, 3.3, and it shows you the range. So because this question would be holistically marked, as it's an extended response question, meaning on the quality of the overall response, even if you included all the correct points and enough points, it's also about how strong your arguments and your strengths and weaknesses are, and how much you went into detail, and how selective you were with the strengths and weaknesses that you chose. That's why only 3% of students were awarded the full marks for the question. Okay, as we can see. You can even see how many students didn't even attempt a question. Obviously, it's always poor practice to leave an extended response question unattempted, because this is 8 out of 80 marks on the examination, so very, very significant. And you can see most students are in this 3 to 4 and 5 mark range. So when you mark yourself as well, you can allocate yourself to sort of predict your study score based on how well you're doing compared to the average, And say if you scored 7 marks, you can see, oh, only 7% of students are in this range. So if you mark yourself consistently for an entire practice exam, and you saw that you were consistently getting the top mark, or almost the top mark consistently, then you could already predict, like, if I went this well on the exam, I would be close to getting a 40 study score, a 40 plus study score for legal, a low 40s, let's say. And the examiner's report also gives you points to bring up in your answers. These are great, um, for the reason that not only if you got stuck on a question and you couldn't think of enough discussion points, you can come up with the idea, but I use these to substantiate my own knowledge and add to my own knowledge. So whenever I read these suggested points, if I found something that I didn't really think of before and I've never used in a response and I like that idea, I used to write it down and add it to my notes and my bank of like ideas for legal studies and answering questions. And high scoring responses from past students. These are so helpful. You can use them pretty much directly to mark yourself, by comparing, your response to the exemplar response. But they're also extremely useful, for learning how to structure your responses nicely, learning how to get more concise as well, because you're going at a pace on the exam of 1.5 minutes per mark, which isn't easy. That's more than a sentence in some cases to get a mark. Um, so you can see some really good examples of structuring, signposting, use of legal studies terminology, which is also an expectation in the subject, and strong points being brought up. So the best thing to do with these is not only use them to mark yourself, but try to take things from exemplar responses and copy that writing style, because these are the high scorers for that year on the examination, the people that get full marks on the questions. So trying to mimic and elicit the same writing style and the same strength of your points um, is great with having a full complete example, which they do give us on the examiner's report. It's really, really helpful. Okay, so now we're up to the end of the study design stuff, and we'll get to the civil justice system. Um, so first of all, we need to do a bit of a revision of the principles of justice, and we'll talk a little bit how you will see some connections in how the application of the principles of justice slightly differs when working with the civil justice system rather than the criminal justice system, which you just would have done. So we know fairness, equality, and access, and we should all be well familiar with these. VCAR requires that you're able to link these key principles to concepts in the course constantly throughout Unit 3. So when you get your examination, the most common, especially extended response questions, and the 10 marker in Section A, they commonly tend to be about the application of the principles of justice to the criminal justice system, the civil justice system, or both. So sometimes you get double-sided questions that need you to compare and link ideas between the criminal and civil justice system as well, which you shouldn't stress about now. You'll get more and more confident in this as you go along, and towards the end of your studies of the civil justice system, all of you will be doing some double-sided questions like that go across both of the systems. So whenever you're learning different concepts, anything in the civil and criminal justice system, you need to be able to come up with points for and against, how they do achieve the principles of justice and how they don't achieve the principles of justice, basically for your discuss and evaluate questions. So what you should be doing is making tables that look a bit like this, note point each principle of justice. You should be able to define them as well. We'll have a look at the definitions in your own words, hopefully, and how a system or process achieves and doesn't achieve. Essential that you have these tables Oftentimes as well in legal studies textbooks, there's not like enough information to make a really strong table for an extended response question um, when it comes to the principles of justice. So you need to add some of your own ideas as well. And if you've got a good understanding of each principle, where you should end up is that you shouldn't have to memorize anything, but you should just be able to come up with points on the spot for each concept. That's why it's really, really important to make sure you're all across the principles of justice, because that's one thing that you can entirely avoid memorizing if you get confident with it. Okay, so here are our definitions. Make sure as well when you're defining each principle of justice, you don't repeat the same words that are the name of the concept in your definition. Okay, so fairness means having impartial and just treatment without discrimination and favoritism. We like this definition because it doesn't say fair. We don't see the word fair or fairness in the definition. That's really important. So it's all about being unbiased and treating people in a way fairly. Okay, so or immediately what concepts think to your head come to your head? You know, an unbiased jury, an unbiased judge. They're impartial. They have no connection to the parties. Um, don't know them personally. Don't discriminate based on personal characteristics. Equality, on the other hand, means that all people should be, it says equal, but we need to use different words. They should be treated the same before the law and have similar opportunities as anyone else. That second part of the definition isn't necessarily important, but all people should be treated the same before the law. So, the same rules of evidence and procedure in court apply to everyone. No one is treated better or worse for the fact that they have some kind of attributes or personal characteristics. Similar offenses, or in the civil justice system, similar uh, civil types of offending, they all carry similar similar penalties. Okay, so like if you got a fine for not touching on your mic here or something, right? The fine is equal for anyone who gets that fine for the first time. You will have to pay the same amount of money as anyone else would have to. So that's an example of equality. Access means that everyone should be able to access the justice system and information. So that means everyone should be able to seek out information about the court system and seek out legal representation and be able to, as a plaintiff in the civil justice system, to initiate and pursue a civil claim. Okay, so we got some examples on the slide of each concept. These are the broad examples, so these are not your concept specific examples, because you need, as we said, to pretty much make a table, make notes for each concept in Unit 3 for how it achieves and doesn't achieve principles of justice. So fairness includes things like fair processes and fair hearing. It means that everyone must be able to understand the court processes and procedures particular to their case. Everyone should be able to do that, usually via the means of, just having legal representation to help navigate the court system. Processes and procedures completed in a timely fashion. So you remember when you study the criminal justice system, the accused has the right to be tried without unreasonable delay, and adequate legal representation. So everyone should be able to seek out legal representation. Lawyers actually cannot refuse their services to someone. So they can't go and think, I don't like this person. I think this person committed a crime, so I'm not going to represent them. So the way that fairness is achieved in this scenario as well is that as long as the person approaching has the ability to pay the lawyer or solicitor or barrister, they cannot refuse their services to them, actually. Similarly, someone who doesn't have the opportunity to get legal representation should be given a duty lawyer. if it's for a serious type of offending, if we're thinking about the criminal justice system, they should have a duty lawyer appointed to them. Everyone has the opportunity to raise a defense that applies again to the criminal justice system. Everyone should know what evidence specific to the case is being brought against them. So we know that in the criminal justice system, during the pretrial procedures, um, the prosecution has to um, show the accused the evidence they have against the accused as well. And they even do things like examine witnesses and allow the accused and their legal rep to cross examine witnesses. So, through this, the accused is able to obtain an understanding of how strong the prosecution's case is and whether or not they're likely to obtain a conviction against them. So this is really useful in terms that it helps us to have much more early guilty pleas by showing the accused the strength of that case. And if they see that it's a bit hopeless going to trial, they're more likely to plead guilty for in exchange for a sentencing discount. Maybe they'll get a shorter sentence if they enter into an early guilty plea. Now, what happens in the civil justice system is that evidence is also shared between the plaintiff, which is the party bringing the claim against the defendant to court, as well as the defendant, the person defending the claim. Similarly, the parties have pretrial procedures, and during these procedures, they engage in a process called discovery, where they have to share evidence with each other that they have against each other. And they are also in civil trials, one of the parties may have evidence that the other party needs for their case, for the purposes of their case, and the parties must actually share that evidence with each other as well. So all their submissions of evidence from each side and all the evidence that they've shared with one another, as the court has deemed it appropriate that they share some evidence pertinent to the case, all of that is shared again, and they develop an understanding of the strength of each other's case, and that can help to reach an early settlement, which is fair. It prevents, it prevents delays and stress and anxiety in the civil justice system as well. Everyone has the opportunity to disprove their respective counsel's case. So again, we have those things like cross examinations of witnesses. um, Everyone has the opportunity to appeal or review a decision made if there are grounds to do so. There must be grounds for an appeal, but technically, everyone has the right to appeal and have an incorrect decision corrected by a superior judge in a superior court if the appeal has been approved. Now, equality. How is it different from fairness? Well, it's all about everyone being treated equally, everyone being treated the same. So, whereas fairness is about not discriminating, okay, and people having the same treatment despite any personal characteristics they might have. So, we can't look, a judge can't look at someone differently if they've got a criminal record and assume that because they have a criminal record, surely they're guilty this time as well of the crime they've been accused of. Now, equality is all about equal treatment. Okay, so we can see that's different. No bias in fairness, equality, completely equal treatment. Okay, so the key idea is all people are treated equally under the law. They all have an equal opportunity to present their case. And people, this is an important point. People should not be treated at an advantage or disadvantage because of a personal attribute or characteristic. And that's why we've got this image of, this small child still cannot see past the fence because all of them only get one box to stand on. Okay? So equality takes people as they are, the same. For any disadvantages or, personal attributes to be corrected, that happens with fairness because fairness tries to make sure there's no bias. So if someone is a vulnerable witness, okay, like they get the right to have those accommodations, like to be able to exclude certain people from the courtroom, to have a support animal when they're giving their statements and being examined as a witness for the trial. So, fairness helps to correct differences in personal attributes that may pose a disadvantage to people, whereas equality means people treated completely the same. So, these would not necessarily be corrected with equality. Equality doesn't correct unfairness. So make sure you don't confuse that, because students often confuse those points. If you want, watch my explanation again, listen to it closely, one or two times until it really, really sinks in. Make sure you don't confuse the two principles. So we see some examples of differences between fairness and equality points. So an example of fairness would be that severe penalties are given for severe crimes and vice versa, because they should reflect the level of offending, and because the sanctions should be consistent across the criminal justice system. As if someone has committed a similar crime with a similar set of circumstances as another person, their outcome, the sanction that they receive and the severity of it, should be pretty much the same. Otherwise, our criminal justice system is not fair. Now, same thing with cases within the civil justice system, for a similar set of circumstances where the plaintiff's civil rights have been offended by another person. Um, the amount of damages or the types of injunctions that that defendant may have to receive if they are found liable, it should be the same for anyone with a similar set of circumstances. Okay. It means they can present their case with strict adherence to rules of evidence and procedure, which also help to ensure that there is no bias in the courtroom. And if people are treated differently, it should be from application of the law, not personal characteristics. So we talked about how fairness may help to bridge gaps if we're, for example, a vulnerable witness, or there's some kind of disability that a person has, a witness has. Fairness helps to try to correct that, to make sure there's no bias for that person, and certain provisions may be provided. Now, equality, being deemed equal in status, rights, and opportunities. Everyone who comes before the law is treated the same. We can already see equality points are just really, really easy to make. Same as like access, because access is all about legal information and time and costs. So it's really simple. And equality, laws should be applied equally to everyone and not provide exceptions or discriminate individuals based on their personal attributes. Reiterating that everyone will be treated the same. Okay, so lastly, access. As we said, it refers to people understanding their legal rights and pursuing claims, being able to pursue claims in the legal system. So knowing your legal rights, knowing that you can initiate a civil claim against someone, or you can report a crime if we're in the criminal justice system, and being able to access legal information and legal advice. So, some examples: everyone should understand their legal rights, everyone should be able to pursue their case through avenues not beyond their reach. And this not beyond their reach is referring to things like time constraints, even your geographical location. So if you live like in a regional area and you're thinking, well, how can I pursue a claim? Like I can't take time off work, and I can't get into an area that has a court system there. It's too far away. As well as costs as well of initiating legal claims, and also the risk of potentially not being successful. As a plaintiff in the civil justice system, there's always the risk that you won't be able to prove that the defendant is liable for the harm that they've caused you. And if that's the case, you will not get compensation, and you will also be left with significant out of pocket expenses for initiating that claim. Now, what are those additional avenues as well that we'll talk about today is that the civil justice system also has not just the courts, but institutions like VCAT that are less affordable and aim to be more efficient and faster than the courts. and also CAV, Consumer Affairs Victoria, which is even a free service for tenants and consumers, specifically consumers that, so if you like buy products and they're faulty, for instance. Everyone should be able to access courts, education, information, assistance, bodies, and institutions regarding legal processes and or advice. So, you'll make discussion points about how this specific service or even the courts, they have information available online that you can access and read about, find out about your legal rights and how court proceedings work. You can talk about legal representation, helping to bridge gaps in access, um, and things like that. And everyone should receive materials from the above pertaining to criminal cases, processes, and outcomes. Okay, so now that we've had a close review of the principles of justice, we can move on from that. But remember that even some because we only have a 2-hour session today, so some of the concepts that we'll be talking about within the civil justice system, I need you to have a think about how you would apply that concept to a principles of justice question. So already start thinking about it in your head as we go through each and any concept. How would you answer a principles of justice question for each and every concept? Because almost anything, yeah, can be a principles of justice question. So the first thing we need to get really into, and this is a handy table for your notes, is the differences in the terminology between criminal law and civil law. So we need to make sure we're really confident in how they differ. Now, in criminal law, we might refer to a crime. In civil law, there is no such thing as a crime. You can call it an offending against the plaintiff's civil rights, or you can refer to it as a wrong, because it literally means in the civil justice system, if a plaintiff initiates a civil claim, it doesn't mean you've committed a crime as the defendant. It means that you've done something wrong. You've breached that person's rights. You caused some kind of injury or harm to them, not through the means of carrying out a crime, but by committing a wrong. In criminal law, we have the prosecution, right? So that's why we also have the term prosecute, because the prosecution brings forward the claim against the accused person. They work on behalf of the state, and they're the ones that are trying to secure a conviction against the accused person. In civil law, it is the plaintiff that initiates a civil claim. So the correct terminology is that they sue, issue, or bring a civil claim to court. I don't see sue being used very often, simply for the reason that that's implying that the plaintiff only wants damages, monetary compensation from the defendant, which is not always the case. So issue or bring civil claim is the preferred terminology. Now, in criminal law, the parties are the prosecution and the defendant. In civil law, it's the plaintiff, which we said is the person initiating the claim, and the defendant. So that's the one thing that's the same in both areas of study, is like you can refer to the accused person in the criminal justice system as the defendant, but be really careful because in civil law, you cannot refer to the defendant as the accused because they haven't been accused of a crime. Remember, it's a wrong. So you can only use the term defendant. Make sure you don't confuse that and make a mistake. Now, criminal law, you have your 5 purposes of sanctions, and it's a lot. In civil law, you learn about the purposes of remedies, and it's a lot easier. They have a general purpose for both injunctions and damages. We'll have a look at today as well. And the general purpose of both is to aim to restore the injured party back to their original position before the harm had occurred to them. And then they've got a specific purpose as well for damages, and there's 2 types of injunctions that you'll learn about. And we'll have a look at that in more detail. So oftentimes when a question asks you to outline the purposes of remedies or explain the purposes of remedies, you often need to provide both the general purpose of both as well as the specific purposes. So that's something important to understand. Criminal law, punishment is sanction. In civil law, it's remedy. So sanction means, you know, punishing someone, sanctioning someone. In civil law, remedy means relief. So essentially, remedy is referring to not punishment but compensation being provided to the plaintiff, relief for the injury or loss that they've suffered. Now we'll look at these key concepts. The standard of proof is different. In criminal law, it's beyond reasonable doubt. In civil law, it's called on the balance of probabilities. As you can already see, that's going to be a much lower standard of proof than in criminal cases, but we need to be able to provide a definition. The burden of proof rests with the prosecution in criminal cases and with the plaintiff in civil law. It makes perfect sense, right? Because whichever party is initiating a civil claim or bringing forward charges against the accused, they should have the burden of proof. That's why prosecution in criminal law and plaintiff in civil law. Criminal law, the defendant will be found either guilty or innocent, whereas in civil law, the defendant will be found liable or not liable. Liable means responsible for the loss that has occurred. It literally means responsible or not responsible. Okay? But they cannot be referred to as guilty or innocent because they haven't committed any crime. So, important to understand. And then we've got original and appellate jurisdictions for courts as well in the civil justice system. But you will have to learn that the civil court hierarchy is different from the criminal hierarchy. So you will have to learn essentially what kind of claims can be heard in what court, just as you did for the criminal justice system. And you will have to know where would appeals go from any tier of the civil court hierarchy. What appeals can be heard in what court's appellate jurisdiction. So that completely changes. Now let's consolidate what we learned about terminology, looking at this exam question from legal studies. Adrian entered into a contract to sell his car to Maria. When the time came to deliver the car, Adrian told Maria that he had changed his mind and he was not going to fulfill his part of the contract. Maria initiated civil action against Adrian. She sued him, and the matter proceeded straight to the Supreme Court. The judge did not have the power to order the case to go to mediation. The burden of proof lay with Adrian to prove that he had not breached the contract with Maria. He was found guilty. Identify 3 errors in the scenario above, and for each error, explain the correct civil process or procedure that should have occurred. So what this question is asking you to do, you can see it's pretty much a terminology question. And there are more than 3 things I believe wrong. So let's break it down. We see that there was a civil breach of Maria's civil rights. There was a contract to sell his car, but he did not do it. Okay? Maria initiated civil action. So far, all good with the terminology. She's the plaintiff, so she has brought the claim to court. Now, some errors. You don't study about this anymore, but this one where it says the matter proceeded straight to the Supreme Court, you talk about how there would be like pre-trial procedures first. That's how you would argue with that point, but you don't study that anymore, so we leave that. The judge did not have the power to order the case to go to mediation. Another error. As part of the judge's powers of case management, the judge will send most cases to mediation before a civil trial, hoping to get an early resolution. And it is very effective. It does help to achieve an early resolution in a lot of civil cases. The burden of proof lay with Adrian. Another terminology error. We just looked at that table, right? Who has the burden of proof? The plaintiff, the person initiating the case. So Maria has the burden of proof. He was found guilty. We know that's also incorrect terminology. That's for the criminal justice system. No crime was committed. And this is the civil justice system. So we can say Adrian was found liable, responsible for the harm that Maria has suffered. And we see this breakdown from the exam. So if you got this question on the exam, this would have been worth a whole entire 6 marks. This would have been a very easy question for most students to do that are just confident in their terminology. Of course, the second mark needs to come with a good explanation, a good correction of the error. So you need to actually explain why the statement is wrong, just like I've been talking through. And we see on this example as well of the examination report. Error, Adrian was found guilty. Correction, as this is a civil dispute, there was no finding of guilt, but there could be a finding of liability. So you need to use the correct legal terminology as well when you're correcting the scenarios. Okay, good. So we've covered the annoying part, I guess, the terminology, and now we'll get into the key concepts in the civil justice system. Should be the first thing that you study in for civil justice system. Now, terminology, the parties. We said the plaintiff is the party that brings the case to court, initiates the civil claim against the defendant, and the defendant is the party that is defending the case. Or you can say, to make sure you're not repeating the same words in your definition, that it's the person that the plaintiff has brought to court. Next key concept is the burden of proof. This refers to which party has the responsibility to prove the case within the trial. So make sure you don't confuse the burden of proof with the standard of proof. The burden of proof means which party has to prove the facts of the case, and the standard of proof means the level of evidence that is required in order to prove liability in the civil justice system or guilt within the criminal justice system. So in civil cases, the burden of proof lies with the plaintiff because they're the party that initiates the proceedings. That's why the plaintiff has the obligation to prove their case. When you learned about the presumption of innocence, I know that's a criminal justice system concept, but it's just the same idea. Why should, when you've been accused of something, why should you have to prove your innocence? It should be the other way around. If someone's accusing you of doing something, it should be up to them to prove that you've done something wrong. So it's the same idea. And that's why the plaintiff has the burden of proof. Now, the standard of proof refers to the extent to which the defendant must be found liable. Or I've always liked my definition better about the level of evidence that is required to prove the defendant's liability or prove that the accused person is guilty. Okay? So the level of evidence that's required. In a civil case, we said it's on the balance of probabilities, which is a significantly lower standard of proof than beyond reasonable doubt in the criminal justice system. You need to be able to define what on the balance of probabilities means. That includes two things: stating that this is a much lower threshold for the standard of proof than in a criminal case, and giving a definition. What's the definition? Well, it means that probabilities, likelihood, right? So it means that the plaintiff only has to prove to the judge that their version of events is the more probable or likely of the two, because probabilities means likelihood, right? So you can define it in a different way as well. You can define it through the judge has to decide which version of the events that is presented, the plaintiff's or the defendant's, is more likely to have occurred. Essentially, the judge picks who to believe in, whose version of the events and the evidence, who seems to be in the right in the situation. Another key concept that you'll learn about is called a class action, or also referred to as representative proceedings. There are a few different ways you can refer to them, but class action is the most succinct, quick, and it makes sense as well. We would have all heard the term class action at some point. Um, you'll need to be able to detail representative proceedings and use them for a bit of questions as well. So you need to know all of the points about when they're appropriate, when they're inappropriate, what are the circumstances in which a class action will be allowed, how are they funded, etc. It's a legal proceeding in which a group of people, specifically, it must be at least seven plaintiffs, or any number. So it needs to be at least seven, but it could be even hundreds or thousands of plaintiffs. A legal proceeding in which a group of people, seven or more, who have a claim based on similar or related facts, bring the claim to court in name of one person. This is a long definition, but when you define representative proceedings, you must have all of these elements: the number of plaintiffs, seven or more, the fact that the claim must be based on similar or the same facts. So the loss that they've suffered must be pretty much equal. If a company has charged these plaintiffs money for a service that it did not provide, in order for all of these plaintiffs to join a class action, they must have been charged the same amount of money for a service that wasn't provided, so they have the same facts, have the same circumstances, and it must have happened around the same time, etc. And then they bring the claim to court in name of one person. So what happens in the class action is that only one case will be heard. Only one case from one member of the plaintiff group will be heard. But whatever outcome is for that person, whether the defendant is found liable or not, it will automatically apply to all members of the plaintiff group. So if they reimburse the one plaintiff and they tell them, yep, you know, the company was in the wrong, they're liable, we found that they shouldn't have charged you for this service, here's your $60 back. That means all of the other plaintiffs in the class action will also get $60 back because the liability of the company was proven. So this is how you see representative proceedings are really, really useful when there are small claims. It's not a significant loss, so it's not worth it to just pursue a class action by yourself because you won't get much compensation and it's going to be too expensive and time consuming to go to court. So why not join a large group of people, and you probably won't even be that lead plaintiff, that one person that does go to trial. So you don't even have to go to trial. You just automatically can join a class action and get the compensation. So it's usually company and business related claims that we see class actions occurring in. Some claims against, yeah, businesses. So you might have seen there's class actions initiated by certain staff members against fast food companies in Australia for not getting their paid breaks. So that's a potential reason for a class action. So we see this happening against companies usually, and where the loss involved is quite insignificant, not substantial. Okay, so they choose that one lead plaintiff, they're called, that will have to go to trial on everyone's behalf. So we said in order to qualify as a representative proceeding, the questions of fact or law that are raised must be similar in all of the cases that are being brought together. So the same type of civil wrong must have occurred to all of these people by the same defendant, presumably so. And class actions are only heard in courts. You can't go with a class action to like VCAT or something. Specifically, the jurisdiction for class actions is the Supreme Court Trial Division for all class actions. Because they're quite complex cases, a lot of resources in preparation, and they're going to be quite time consuming while all of these people are gathering a big group of plaintiffs together and accumulating evidence against the company, and the company is trying to defend itself. So these are the specific requirements of when a representative proceeding can occur. If a group of people all have claims against the same party, they may be able to commence a class action together if 7 or more people have claims against the same person. So again, the number of plaintiffs must be at least 7. Those claims relate the same, similar, or related circumstances. So they don't have to be the exact same, but they have to be very, very similar, and the civil wrong has to be very, very similar that has occurred. And the same issues need to be decided. So this means that the reason that they're bringing a claim against the defendant must be the same. Okay, so when they initiate a claim, they outline what the defendant did wrong and what kind of compensation a plaintiff wants from the defendant. So they need to be able to agree on all of this in order to be part of a class action. I can't go and say, I'm a member of the plaintiff group. I want compensation for the service I haven't been provided. I just want the same amount of money that they charge me. Okay? And then another plaintiff rocks up and says, actually, I want an injunction to shut down the company because they keep charging their customers for things they don't provide. That's not the same issue that needs to be decided anymore. This plaintiff wants something different than the other plaintiff. So, unless they change their mind, they cannot be part of this plaintiff group because they don't want the same remedy. They want something different. If these all apply, a class action can proceed in the name of one person. We said the lead plaintiff, who will actually go to court and engage in proceedings. And this occurs on behalf of all the individuals that are part of the claim, which are referred to as the group members, or you can say the plaintiff group members. So I mentioned some of the benefits of representative proceedings, but the benefits of a class action, the group members can share the cost. I mentioned that this usually occurs for relatively small claims where not as much of a significant loss has been incurred. So that's why people may not want to initiate a claim by themselves, because if they lose, they lose a lot of money if they don't prove the liability of the defendant. And even if they win, they still paid legal costs and legal fees to go to court. So they still lose money if it's for a small claim. This is why it's important for group members to have the ability to share the cost. It's also a more efficient way of court dealings that saves court time. People can pursue civil action they may not be able to afford on their own, enabling access. Um, so we said how court time is saved because only the lead plaintiff's claim will be heard, and that will help to find a resolution for all the other plaintiffs as well. It helps to breach the cost of going to court, enabling access, and in some claims, a litigation funder may be prepared to fund the class action. So what commonly happens for class actions is they end up being free for the plaintiff group. It ends up being funded. Someone like a law firm or a litigation funder may come forward and offer their services. They may offer to represent the plaintiff group for free in trial and to fund the expenses of their class action. Now, why would they do this? Have a think about that. So the reason that they will do this is um, because if they'll usually have an agreement for the plaintiffs, which will essentially say, we're going to represent you for free and fund the class action, but if we successfully prove the liability of the defendant, you will have to give us a percentage of the compensation in damages that you will be given through the court order if you're successful. So they might take 10% of all of the damages of the class action and make a hefty profit. But the other thing as well is they'll only take money if they've prove the liability successfully if the plaintiff group is successful. So if they don't prove the liability of the defendant, the law firm or litigation funder that has come forward and made this offer, they won't take any money from them at the end of the day. So the class action would have been free. So you can see how it helps to mitigate the risk for the plaintiff group of losing the claim and losing even more money because these law firms will do it for them, will fund it for them. Okay. So, benefits and disadvantages for the individual. Yes, there are disadvantages for the plaintiff group too. So, we've talked about how it will allow them to pursue a case that they otherwise might not have been able to afford to pursue. It helps to bridge access. It helps with time issues as well because the lead plaintiff will be doing everything on their behalf and they don't even need to be involved. And that the large corporate law firms will take on class actions for free or minimal cost to the plaintiffs. It's great publicity for them, and it's a lot of money if these claims are successful and the plaintiff group agreed to a percentage of the damages that they'll get as part of the court order. Disadvantages, though, are we said there's only lead plaintiff that does everything. So the other plaintiffs in the group might feel that they have a loss of control over their case. They don't know how it's going, they don't have the ability to submit evidence to make decisions with regards to the trial and the evidence. It's all up to the lead plaintiff. So it's less individualized, causing people to feel unimportant and that their voice isn't heard within the case. But we can't correct this because if 100 or 1,000 people come forward for a claim with the same circumstances, the courts don't have the capacity and the resources to hear 100 to 1,000 different claims about the same thing. So nothing can really be done about these disadvantages. For the courts, it's a streamlined process of a representative proceeding, meaning that multiple individual cases with the same fact scenario are not tying up court resources, helping to prevent backlogs. However, once again, less focus on individuals within the courtroom. So, potentially a bit of potential for making a mistake as well. So, if there are all these people and their circumstances are similar, there's always the risk that the court's um, outcome is incorrect. That remember, because the standard of proof is only on the balance of probabilities. So there's always the chance that someone else could have been the lead plaintiff and could have had a stronger case against the defendant that would have been successful, or the chance that the company didn't do something wrong, or the chance that some of the members in the plaintiff group didn't suffer the same extent of civil loss and they shouldn't get the same remedy given to them and the same amount of damages. So there's always the potential for many of those things. Okay, so now that we've talked about all of the key concepts and representative proceedings and key terminology, we've already covered a huge chunk of the civil justice system. So let's apply it to some activities. We need to correct the scenario. What's wrong with each scenario? Scenario 1, John entered into a contract with a woman named Alice. A week later, John breached the terms of his contract with her. Alice decided to initiate civil proceedings against John. John had to prove the facts of the case, however, he was found to be guilty. What are the terminology errors in this scenario? Alice has to prove the facts of the case, not John, because she's the plaintiff bringing the claim to court. John cannot be found guilty. It's a decision of liability in civil proceedings. Scenario 2, Jordan recently had some issues with a hair dyeing product. The product had burnt part of her scalp and left her with severe burn damage. Jordan found 4 other women who had experienced the same issue, so they decided to start a representative proceeding. Another man asked Jordan to join. He had a problem with a razor from another company, to which she agreed. The group ended up winning their case, but had to pay money to the hair dyeing company for their losses. What's wrong with this scenario? First one, Jordan found 4 other women. So how many members does that make in the plaintiff group? 5. What's the minimum that we need to initiate a class action? 7. So we cannot have a representative proceeding in this case. If they all wanted to initiate a claim against this company, they would all have to do so individually and individually take the company to court. Next mistake. Another man asked Jordan to join. He had a problem with a razor from another company. What element of representative proceedings does this not satisfy? So this man has a razor from another company. So there is a different defendant. So we don't have a related set of circumstances to allow this man to join the representative proceeding. His defendant is a different company. He has a different defendant, so he cannot join the group. Now, if the group ended up winning their case, that's okay. We don't like to see that because there's no legal terminology being used. We should say the group ended up proving the company's liability, but that's fine. But this statement, they had to pay money to the hair dyeing company for their losses. So obviously, the remedy will be afforded to the plaintiff group. So it is the hair dyeing company that will have to give damages to the plaintiff group, and additionally, because the plaintiffs were successful in proving their claim, the hair dyeing company will have to pay additional money to the plaintiff group to cover part of their legal proceedings costs. It never ever fully covers your legal expenses, but it covers part of it, and it's called an adverse cost order. We'll look at it today as well. Last one, Alex had posted a defamatory article about Mia. Defamation is where you say things that are false about someone at the bringing harm to their reputation. Mia decided to bring a claim to court regarding defamation. Alex had to prove beyond reasonable doubt that she posted defamatory material. What's wrong in this scenario? Mia has to prove, because she is the plaintiff, not Alex, and the standard of proof is on the balance of probabilities. Good. Hopefully that helps to consolidate everything. Our next topic is the factors to consider when initiating a civil claim. And on the study design, you've got 3 of them. The first one we'll talk about is cost, which is really, really easy. So this is essentially the things that the plaintiff has to think about to decide if it's worth bringing a claim to court against the defendant. So they actually have to determine if it's worth it or not. Costs, you need to be able to define it. It's any cost associated with interacting within the civil justice system or bringing forward a civil claim. And what are our concerns as a plaintiff when it comes to costs? The cost of initiating a civil claim and continuing it through a trial can be incredibly high. So, plaintiffs, before initiating a civil claim, need to consider many things. The cost of actually initiating the claim, because you have to pay for that too. To initiate a claim through the courts, you have to pay a fee. The cost of lawyers, so paying for a barrister for the duration of the trial to represent you in court, and paying for a solicitor for all of your legal documentation, including additional expenses. Any money that you might lose due to having to travel for trial and having to be away from work for the period of the trial as well. Very, very expensive. Courts will also have daily hearing fees, and the higher the court is within the court hierarchy, the higher the daily hearing fees for your trial will be. Okay? And if you request a jury in civil cases, because civil cases never have a jury automatically given to them, we have juries for indictable offenses. If there is a jury within the civil system, it will have been requested by one of the parties that they just prefer to have the decision decided by a jury, and they actually have to pay for the jury if they're requested as well. So that's an example of an additional cost. So this is where it says that a jury in a civil trial is not an automatic right. So if one of the parties requests a jury, they must pay, unless it's the judge that has requested a jury, which doesn't really happen. There'd have to be a specific reason for the judge requesting a jury. So these costs, you need to be able to give examples for questions. Legal representation, court costs, including initiating a claim, daily hearing fees, other disbursements, if they pay for a jury, and if they pay for expert witnesses. So they might pay for experts to come in that can analyze evidence and basically say, "Oh, I've got an expert background. I can tell you that these scissors wouldn't have ended up in your stomach naturally during surgery, and the surgeon, that's the defendant, must have left them there." So like they will be experts in their own area, and a plaintiff might use them to basically make their evidence stronger. And possible costs to be paid to the other party. So I mentioned this term, adverse cost order. This is really important when you're discussing costs in terms of the plaintiff having to decide if it's worth initiating a civil claim or not. So if the plaintiff is not successful and they do not manage to prove that the defendant is liable for the civil harm that has occurred and the breach of civil rights, the plaintiff will be given an adverse cost order by the judge, whereby they will have to pay for the defendant's legal fees in going to court because they didn't successfully prove that they did anything wrong. So now they have to reimburse them for their court costs. Okay? Same kind of thing. If the plaintiff does prove that the defendant is liable, however, if they're successful, the defendant will get the adverse cost order. So on top of any damages, they'll also have to pay for the plaintiff's court costs and legal fees. But it doesn't cover everything. It doesn't cover all costs. So another thing that the plaintiff has to consider is that even if they're successful and the defendant has to pay for their legal fees, they will still be left with some out-of-pocket costs. Okay? So if the plaintiff initiates their claim and it is unsuccessful, they not only pay for their own legal costs, but also some of the defendant's legal costs as well. Note that it says some, because the adverse cost order never covers all of your legal expenses, just some. The idea of an adverse cost order can deter plaintiffs from initiating claims because it's a fear of losing even more money if you're unsuccessful. So if you're already in a bad position, the idea that you'll lose even more financially. So some examples of costs you can see on the slide there. Very, very expensive. Very expensive. Okay, the next factor to consider is the limitation of actions period. Pay attention to definitions, quite easy. It's exactly what the words sound like. It refers to the restriction placed on the time period within which a civil action can be commenced. So for almost every type of civil wrong, there is a time limit on how long the plaintiff can wait until they choose to initiate a claim against the defendant after the wrong has occurred. So they have a time limit. Legislation sets out the number of years that a plaintiff has to bring a claim following the harm or action of the defendant before they are barred, forbidden from bringing the claim at all. For instance, for defamation, lying about someone and ruining their reputation, it's 12 months. There are still some circumstances in which the court or the judge might increase or remove the limitation period for a certain person, for a certain plaintiff, but there's a very high threshold that the plaintiff must be able to meet. So a good example would be if I was the plaintiff and I didn't make this 12-month period for defamation because I was in a hospital and I was in a coma. So I wasn't physically able to. So it would have to be something like that. Like, remember, very high threshold. So very little exceptions will be made. Why do we have this? It wouldn't be fair for a defendant to wonder their whole life if someone's going to initiate action against them at some point for something that happened. And also, importantly, we need the evidence and the facts to stay fresh. We need to make sure they're not lost over time, okay? So that we can have a fair trial. The limitations are listed in the Limitation of Actions Amendment Act of 2002 in Victoria. And again, we said there can be extensions, but very difficult to get. So, the reasons on limitations that you need to know: the defendant does not have to face action after an extended period of time, what I mentioned, limiting their stress and anxiety, that's fair. Evidence is not lost, and people can still remember what happened because evidence would be naturally lost over time, and disputes can be resolved as quickly as possible to promote social cohesion. Examples: adult injury claims causing, such as through a workplace accident, injury to a plaintiff, it's 3 years. It used to be 6. Defamation, we said 1 year or 12 months. It's good to know an example or two, but you don't really need to. That's one thing you can skip. And our last factor to consider when initiating a civil claim is enforcement issues. It's exactly what it sounds like. They are the complications that can occur during the application or execution of a court order, meaning that plaintiff was successful, they prove that the defendant is liable in the end, but there are issues with the enforcement of the court order. There are reasons for which that it may be impossible for the plaintiff, even if they were successful, to actually get the compensation from the defendant. So you need to know some examples. And these are commonly placed with stimulus materials. So be able to find, ideas in your stimulus material. If the defendant is bankrupt, they cannot pay the plaintiff. That's why they cannot compensate them. That's why they cannot pay damages. They don't have any money. If not bankrupt, the plaintiff may still be unable to pay. If it's just a high sum, the sum is just too high for them based on how much money they have, defendant may be in jail. So they may also be pretty much, they don't have access to money if they're in jail. If the defendant has a company, the company may not have assets. A different way to say they have no money. The defendant may be overseas or uncontactable. In that case, it's impossible to force them to compensate the plaintiff, especially if they're in another country. And whether they even know the defendant. So if you don't even know who exactly you're issuing the claim against, such as it's some kind of dodgy business that doesn't have, you don't know the owner's name, their home address, nothing. It might even be impossible to initiate a claim because the courts don't know how to get the claim to them. So that's a different type of enforcement issue. There's also 2 different institutions that you need to know on top of the courts that can be used for civil claims. I mentioned before, CAV and VCAT. We'll look at each one. So Consumer Affairs Victoria. You need to, again, be able to compare these 2 institutions with one another. So keep that in mind as we go along. Now, CAV is a free dispute resolution body. It's completely free. So that's the key advantage that it has over the courts. It uses conciliation as its primary method of dispute resolution. This means there is no court hearing. There is essentially an alternative dispute resolution method, and you will need to know all 3 of these: mediation, conciliation, and arbitration. Consumer Affairs Victoria uses conciliation. I might just skip forward to show you that slide. Let's run through this now, I think. So this is what you need to know. Mediation is an alternative dispute resolution method that uses a third party called a mediator that will listen to both sides of the dispute. So listen to both the person that thinks their civil rights have been offended, as well as the defendant. Listen to both of them, and will help to facilitate discussion between the 2 parties. So it helps to maintain a good relationship between them and essentially keep their conversation on track, make sure they're discussing the issue and potential settlement. But the mediator cannot provide their own opinion and solutions. So this is how conciliation is different. Conciliation is like one step up. Whereas mediation just facilitates discussion, helps to discuss the issue. Conciliation also facilitates discussion, but also provides suggestions and provides ideas for the resolution. The third party in conciliation is also called a conciliator. They are not just kind of random person like the mediator, but a conciliator has to be specifically an expert in the particular type of dispute that these people are having. So they also bring their own expert knowledge to it, and that's why they're allowed to give suggestions and solutions. Now, arbitration is the last one. Arbitration is like it's very similar to a court hearing. It's just slightly less formal and it's a lot shorter than a court hearing. So, arbitration uses a third party called an arbitrator, which is also an expert, a legal expert. The arbitrator listens to both sides of the dispute. So, parties have to, just like in a civil trial, they have to present evidence and argue for their side. And then the arbitrator will provide a legally binding decision, meaning that if they say defendant is liable, you have to pay this many damages, that is legally binding. That is the final decision. Mediation and conciliation do not provide legally binding decisions. So you can already see why certain people might want to use them, might not want to use them. They're much more informal, but there's no legally binding decision. So we need to be able to trust the other party that they will uphold the agreement. We need to be able to believe them. Okay. Now, the only exception is if you go to mediation or conciliation through the courts, like the judge sends you before a trial, the plaintiff and the defendant to mediation or conciliation. If it's done through the courts, then it might be legally binding. You might sign a contract that says an outcome has been reached and this is the outcome. Okay? So let's look at CAV again. CAV uses conciliation, where we have an expert in the issue and it's an informal discussion setting and they suggest solutions on how to reach a settlement. The jurisdiction specifically of CAV, it's a free service, but it's very small. It's only consumers against traders and businesses and tenants against landlords, meaning that landlords cannot initiate claims against tenants and businesses initiate claims against consumers, only the other way around. This is a consumer body. It's for consumers and tenants specifically. Yeah, so they do things like ensuring businesses comply with consumer laws, helping people to exercise consumer rights, providing fair and safe residential tenancies for renters. You need to be able to discuss in questions when would CAV be appropriate or inappropriate. So one thing to consider is whether a dispute is within CAV's jurisdiction is the very first thing. If it is, there's automatically a reason why CAV is appropriate. However, CAV does have a small jurisdiction and you need to know it. So you might read questions and see this actually can't go to CAV. It's not within their jurisdiction. Now, whether the dispute is likely to settle. What did we say? Conciliation, which is used by CAV, it's not legally binding. And the conciliator helps the parties to discuss and gives potential solutions for their issue. But they cannot force them, just like mediation can force them, they cannot force them to come to an agreement. And they cannot force them to uphold on the settlement because they just agree to it by word. It's not legally binding. So we need to see if we've got a stimulus provided. Do the parties trust each other? Does it look like the parties are willing to cooperate, willing to discuss the issue? Now, whether the parties are willing to participate in conciliation at all is another important one, because they cannot be forced to attend. They actually cannot be forced to show up and discuss the issue and try to come to a settlement. And whether there are other or better ways to resolve the issue. So, for example, if there is an issue based on a point of law or clarification in the law that needs to be made, this just needs to go to court. This just needs to go to an expert judge. So put it all in a table. When's it appropriate? When parties have limited money. Why? Because CAV is free. So why not try to pursue a free avenue first before you do something else? If they're willing to discuss the issue and able to come to the resolution themselves, so there needs to be cooperation between the parties. Alternatively, when parties refuse to discuss the issue, CAV cannot force this to occur. When parties refuse to show up to conciliation, again, CAV cannot force it. And importantly, if a case does not fit under their jurisdiction, it must be initiated by a tenant or a consumer. So that's very, very narrow. Now, looking at VCAT. The purpose of VCAT is to hear smaller civil cases more efficiently and effectively. It has a huge jurisdiction. It almost has a similar capacity to that of the courts, but it cannot hear matters that are for a very, very large amount of damages or where complex issues of law are involved. And we need a judge to decide that. So it does things like reducing costs such as lawyers, certain fees, and uses a free tier payment system. So there's different costs for different types of civil claims to try to make it more affordable. And dispute resolution is generally much faster within VCAT than the courts, not only cheaper. For example, average time taken to resolve dispute in the civil claims list in 2015-2016 was 10 weeks, much faster than the courts. There are also less formal and less costly procedures. So when determining appropriateness of VCAT, what do we need to think about? Whether the dispute is within VCAT's jurisdiction. Generally, VCAT's jurisdiction is so big, everything that you'll read about, any stimulus material that you'll get, it's within VCAT's jurisdiction. It will be some kind of civil claim, okay? So that will always be a no-brainer. The cost and time involved, essentially, do one of the parties or both of the parties care about saving time and cost? If so, VCAT's appropriate. Whether the parties can resolve the dispute themselves. That would be the preference. Because why would they go to VCAT? VCAT will give them a legally binding solution. And it will still be more time consuming and more money involved. If the parties are willing to resolve the dispute themselves, they should go to a mediator or a conciliator and try to engage in discussions about a settlement first. If the parties prefer the formality of the courtroom, they should just go to court. If the matter is large or complex areas of the law involved, such as a class action, also inappropriate for VCAT, needs to go to courts. And doctrine of precedent. So the idea that VCAT has incredibly limited opportunities to appeal. This is referring to the fact that if you go to VCAT over a claim, the only way you can appeal to courts is based on a point of law, based on the law being applied incorrectly. You can apply for an appeal based on who was found liable. You can apply based on the amount of damages given. None of that, only on a point of law. So there's very limited opportunities for an appeal. So VCAT is appropriate when a party wants to resolve their dispute through mediation or arbitration, because that's the methods that VCAT generally uses. Go back to those and revise them. So generally VCAT will try mediation first, and then there will be an arbitration hearing, the more formal one, the one that comes back with a legally binding decision. So that's an actual VCAT hearing. It's like a court hearing, but it's a less formal version of that, and it's a much quicker version of that as well. When a party doesn't wish to go to court but wants a legally binding decision, VCAT is perfect for that. We want to have an arbitration hearing. When a party does not wish to have a lawyer or cannot afford to go to court, again, we said VCAT is cheaper, quicker, and additionally, you may not even have a lawyer. You might find that you don't need one for a VCAT. Inappropriate when because it can still be expensive. Sometimes waiting times are quite long for some of the lists, some of the civil claims, and if a case does not fit under VCAT's jurisdiction. So you need to be able to compare VCAT with CAV. VCAT is a tribunal. CAV is a complaints body, and it's actually established by Parliament, even though it's considered independent. We've got their jurisdiction outlined. It's easier to just remember for CAV, tenants against landlords and consumers against businesses, and we can see VCAT's jurisdiction, any administrative disputes, civil disputes, human rights, residential tenancies. So covers anything within the civil justice system. We just need to make sure it's not a complex matter in terms of application of the law or the monetary jurisdiction. So it can be for like a super substantial amount of damages. That would have to go to court. VCAT uses all methods: mediation, conciliation, and arbitration for its dispute resolution. CAV only uses conciliation and is not legally binding. VCAT is legally binding. And CAV, key difference, is free. All right. Let's have a look at applying a stimulus material to consolidate what we've learned. Kai's in a dispute with his landlord. The landlord refuses to repair the pipes in the bathroom and has declined Kai's request to resolve the matter. Kai's been advised that Consumer Affairs Victoria is the most appropriate body to resolve the dispute. Explain one reason why CAV may not be the most appropriate body to resolve this dispute. So specifically, one that it is not. We know why it is. It's within the jurisdiction, right? Kai is a tenant, and the landlord wants to initiate action against his landlord. So CAV is within the jurisdiction. What's the reason from the stimulus why CAV is inappropriate? Well, the landlord refuses to repair the pipes, declined Kai's request to meet. So because CAV cannot force parties to negotiate and even to attend conciliation from the stimulus, it sounds like the landlord is not willing to negotiate and is not willing to show up to conciliation. That's why it's inappropriate. Okay, good. That's an example question. There's some long ones as well. Just because of timing, we won't go through it, but I recommend having a go. Try to think, apply the stimulus. Some good questions there. Now let's have a look at the civil court hierarchy. So when you did the criminal court hierarchy, you needed to know two reasons for the court hierarchy. One was appeals and one was specialization. For the civil court hierarchy, you need to know administrative convenience and appeals. So appeals is all the same. It involves a party that is dissatisfied with the outcome of the trial. So both the defendant or the plaintiff can initiate an appeal. They can have their own reasons for it. It doesn't have to be the plaintiff because their claim was unsuccessful. Don't get that misconception. Any party can apply for an appeal. And essentially, they appeal to a higher court to rehear the case, have the trial again in a higher court. Why is this important? Need to answer that in questions. This allows for matters to be taken to higher courts where cases can be heard with more superior and specialized judges that have extensive knowledge and expertise. Essentially, a superior judge in a superior court will be able to review and correct any mistakes, which is fair. Okay? Administrative convenience. The existence of the court hierarchy allows for civil cases to be distributed according to their complexity and seriousness, meaning that less serious or complex cases are heard in the lower courts, such as the magistrate's court, and you need to always give an example, such as the magistrate's court, and whereas more serious and complex cases will be heard in the higher courts, such as the Supreme Court Trial Division. It's called convenience because it allows the courts to allocate their time and reduce delays and backlogs in the court system. So a magistrate's court will hear a very high volume of cases, but they're also much more minor, so they don't need to devote a lot of time to their resolution. So they're just resolved quickly, and the highest volume of cases go right through the magistrate's court and they're solved there. The Supreme Court Trial Division will hear very complex cases in comparison to the magistrate's court, but there will also be a lot less of them. So by having them all go to the Supreme Court Trial Division, it means more resources and time can be allocated to their resolution. Okay? And that's how it all comes together. Don't confuse administrative convenience with specialization. So appeals, what are the reasons, the grounds you can appeal based on in the civil court system? It's either a question of fact, that means liability. So you can argue, the defendant can appeal saying that they weren't liable, but they must have sufficient grounds to show that there is a good reason for them to appeal. Or the plaintiff may have failed in proving that the defendant is liable, and they can appeal based on the fact that the outcome was wrong. The defendant is liable. Okay, so that's called a question of fact. It can also be based around the amount of damages, them being excessive or insufficient, or a question of law. A question of law, same as you had in the criminal justice system. Gaps in the law need to be filled in, or it hasn't been interpreted and applied correctly. Okay. Now, administrative convenience. Civil cases can be distributed according to their complexity and seriousness, we said. So you need to be able to give that example. Minor matters heard in magistrates' court, such as, and it's a high volume, but it goes in a very short time because they need less resources, versus more complex cases have to go to the higher courts. So give that example when you define it. We said it helps to reduce delays. As an example, so an example you might put in a response to a question. The magistrate's court can only hear civil cases that are worth up to 100,000, whereas the county court and Supreme Court trial division can hear cases worth any amount. So this is, when I said the civil court hierarchy is different, so this is what we're talking about. Magistrate's court can only hear claims up to $100,000, but county court and Supreme Court trial division, unlimited amount. Anything above the magistrate's court is unlimited amount of money. Okay? So that's what the claim is going for. That's how much money the plaintiff is asking for from the defendant. That's what this money is. Okay? This threshold. So, what's the difference between specialization and administrative convenience? Administrative convenience refers to civil cases being distributed according to their complexity and seriousness, whereas specialization refers to judges hearing the same types of cases over and over and over again, and therefore developing their own areas of expertise or specialization. So you can see they're completely different. Specialization, skill, due to repeated exposure. Administrative convenience, distributing different types of cases to help reduce backlog and save time for the courts. Okay, so this is, I won't read this out, everyone can read, but this is your civil court hierarchy table that tells you what type of claims go where. Just add as a note, the Supreme Court trial division, class actions go here specifically. They can't go to the county court, they can't go to the Supreme Court of Appeal. And you've got your appellate jurisdictions defined as well. Okay, next little bit of content, key personnel. So the study design has taken one off for you. Previously, it used to be the judge, the jury, the parties, and legal representation as well. Now you've just got the judge, jury, and the parties. You would have done this for the criminal justice system, but you need to know how the roles and aspects of the concepts are different in the civil justice system. You can even get a question that asks you to compare the roles of key personnel within the civil and the criminal justice system. That can be a thing. So let's go through it. First of all, the judge, be able to define. We know that's an independent and impartial adjudicator that ensures both parties receive a fair trial. What are some of the responsibilities of the judge? They're there to ensure that the strict rules of evidence and procedure in the courtroom are being followed by all parties. They help to decide questions of law. If the law needs to be interpreted, they will do that. And they also decide the remedy. If the defendant is found liable, they will decide how many damages or an injunction that the plaintiff should get. They decide the remedy. Now, this is where things start to change in the civil justice system. Sometimes the jury can decide the remedy. You don't need to know about this, but you need to know that this is a point. Both the judge and the jury have the role of deciding the remedy. However, the jury will only decide, first of all, if a jury is appointed in the first place. We said it's not an automatic right to a jury. And it's only for certain types of civil wrongs that the jury is allowed to decide the remedy. Only for certain types. You don't need to know these types, but you need to know that it depends, okay? And you need to outline that when you're answering these questions. The judge will also make a decision on the facts of the case if a jury is not present. So if a jury is appointed, they will always decide if the defendant is liable, but they will only sometimes be able to decide the remedies. Yeah, it's a little bit confusing. But usually we know we don't have a jury in civil trials, so usually it will be the judge doing both these things. And they will also use their powers of case management, which we'll have a quick look at, but that's the power to give directions and order parties to attend mediation. They will use those powers of case management to ensure a just and timely resolution. Try to make it as efficient as possible, but still fair for the parties. So you need to be able to discuss strengths and weaknesses. Strengths: the judge is an impartial umpire, unbiased, ensuring a fair trial that parties are treated equally. No one's given any advantage. If there is no jury, the judge will decide on the facts as well as law, ruling on liability and remedies. Um, so this is a strength because the judge is a legal expert. So it makes sense for them to make the decision, probably the most accurate decision. Okay. They have significant powers of case management to oversee that just, timely, and cost effective resolution of issues in the dispute. So they will use their powers of case management to make trials as efficient as possible, but still as fair and just as possible. Weaknesses: potential for unconscious bias. They cannot overly assist the self represented party, or only give them basic direction and instruction. So self-represented parties will be at a disadvantage, and they cannot overrule a jury verdict even if they disagree and think it's wrong. Now, our jury, how is it different from the criminal justice system? It's not automatically appointed. As we said, a party has to request it and pay for it, and it's only 6 members. Okay? 6 impaneled members of society who listen to a case presented before them and then give an impartial verdict. So the jury is only 6 people for civil cases. Their responsibilities: they make a decision on the facts of the case. If appointed, we talked about this, they decide liability, decide the damages or remedy, only for some civil claims, not for all. They take part in deliberation, they have to put aside their prejudices, they have to remember the evidence and take notes, choose a foreperson to represent the jury, listen to the judge's instructions, all the same kind of roles you learned in the criminal justice system. So some strengths. We ensure that there's no bias because they're randomly picked from the electoral roll and they will have no connection to the parties. They can only decide on the facts before them and based on facts of law. So they're also prohibited from making their own inquiries, talking about the case, or accessing any information about the case while they're part of a trial. And it also ensures decision making is shared. It's not one person deciding the liability if it was the judge, but now it's 6, which might make the plaintiff and defendant feel that it's a bit more fair to have multiple people making the decision. Also, the fact that they're members of the community, that can be really reassuring to people. Similar weaknesses: might have unconscious bias, might inadvertently come across information about the trial. Exposing them to that information can bring an unfair outcome, but it can happen with a high publicity case. Jury may not always be representative of the community. Obviously, it's only 6 people. And it's a difficult role to listen to, remember all the evidence, and follow complex jury directions. And these people are not educated in the law. They are not legal experts at all. So there's a bit of a risk that comes with that for an incorrect outcome. What are our parties? Of course, that's the plaintiff and the defendant. So first of all, these are the key responsibilities. The plaintiff has to prove the facts of the case. They have the burden of proof. The defendant is defending the claim. They both have to present the case to the judge or jury. Same as in the criminal justice system, they'll have things like opening and closing statements to summarize their case and their key reasons why each party is right. And they have to comply with overarching obligations. So learn a couple of examples of these. I've added the text here. They apply to any person who is a party. 10 obligations outlined in the Civil Procedure Act. And their legal reps have to follow them as well. So I've highlighted some of the ones that are easy to remember, and you can outline them as 1 or 2 of the responsibilities of the parties in a civil trial. Acting honestly, minimizing delay, Disclose existence of any documents, so share any evidence that is requested by another party. I mentioned discovery before, like much earlier in our lecture. And not to mislead or deceive. So acting honestly and not misleading or deceiving are already two different ones. So try to learn some of those. Put down the easy ones in your notes. So party control is key to parties. In Victorian civil trials, the plaintiff and defendant control their own cases and make decisions as to how their case will run. And much more often, it's the civil justice system where parties might not have legal representation. So there's party control, but parties to civil cases are limited in that they tend to rely heavily on the advice and assistance of their legal representation. So this means that if someone has bad legal representation in comparison to the other party or is unrepresented, they're likely to be greatly disadvantaged in court and receive bad advice or poor legal assistance and end up with an incorrect or a negative outcome in that trial. So strengths: party control allows parties to make decisions about evidence to put forward and submissions to make. This is the most fair. They will feel like they had control over their case the whole time, and the outcome that they got was deserved. They did everything that they could. They used their party control to make those conscious decisions. Again, that they're all required to comply with overarching obligations. So both the plaintiff and defendant cannot deceive the court, must act honestly. All of those things that ensure that a fair trial is in place. Weaknesses: through party control, vital evidence may be missed. Parties can make poor decisions. And this might also be the fault of legal representation being unbalanced. An unrepresented party can cause delays. Highly complex legal procedures might be very difficult to understand without legal representation. Again, bringing forth the idea that the outcome might be incorrect because a party doesn't have legal representation or it's poor legal representation. And it may be difficult to prove that a party is not complying with obligations. So, for example, how can we prove that a party is not using reasonable endeavors to resolve the dispute? If they're trying to drag the court proceedings out, but they haven't gone against a deadline technically or done anything like that, how can we prove that they're not trying to resolve the dispute? Or how can we prove that a party is misleading a little bit? So that's the problem. We have those protections, but it's very difficult to prove anything. All right, finishing up, what did we bring up? The judge's powers of case management. So let's have a chat about it. These are the powers that Victorian judges have within the civil justice system given to them by the Civil Procedure Act 2010. And you need to know two of them. The power to refer a civil case to mediation. I talked about this before. I said for almost every single civil claim, judges will send the case to mediation first to try to see if an outcome can be obtained, avoiding the time, the costs of a full trial. And if you do this through the courts, that mediation can be binding, okay? Because it's done through the courts, so you can still get a binding outcome, but it still means that both parties need to be, willing to negotiate, willing to come to some sort of agreement or settlement. That's where it can fail. And the power to give any directions that they deem necessary for the case. So this is all about making it faster, dispute resolution in the courts, cost effective, while still being fair and just. You need to know this purpose, this line here at the bottom. So we need to be able to give examples of some directions, okay? So yes, the order to mediation, this is a meme that shows it's like always happens. Like you pretty much always have to go to mediation, which the plaintiff might not be pleased about because the defendant is not negotiating with them. But it is more effective than not sending them to mediation. Like it still helps to resolve a lot of disputes. That's why it's done. Are examples of the power to give directions that the judge has. There are any instructions given by the judge that compel a party to do something, usually by a certain time, usually with a deadline. So know a few examples. They can limit the scope of discovery, the evidence that can be submitted to trial and shared between the parties during that pre-trial procedure stage to ensure it doesn't take too long, because discovery is very time consuming. So the judge might limit the types of evidence that the plaintiff and the defendant can submit in preparation for the trial to try to just get it done. Make sure it's only the relevant stuff that they'll need in trial. It can also include participating in any methods of alternative dispute resolution, not just mediation. The judge could send parties to conciliation or arbitration as well. Fun fact, for magistrates, for claims within the magistrate court, any claim under $10,000 will get sent to an arbitration hearing. So they all end up having an arbitration hearing. Also, restricting the time for final hearings, including limiting the number of witnesses and the time to make submissions or cross-examine witnesses. So, might reduce the number of witnesses to make sure they're all relevant, and might reduce cross-examination time to make sure that procedures just move along a bit more smoothly and quickly. I introduced this a bit earlier. We've gone for the alternative dispute resolution methods. You can review them here. Remember that courts can use any of them, but commonly they just use mediation. Okay, this is a comparison. We've already talked through this. This is a great table, but you can see some differences because you can get questions where you might have to compare the differences between mediation, conciliation, and arbitration. It's all in a table here for you. Our last concept for today is remedies. So we said that this is the compensation, the relief that is given to the plaintiff. It's the means by which a plaintiff's civil rights are protected or corrected for injury caused by a defendant. And we need to know this general purpose of civil remedies: to restore the injured party back to the position they were in before the harm occurred as much as possible. The two types of civil remedies are damages, which is the most common one, and injunctions. And in this definition, we also have their specific purposes as well, guys. So it's really all in one slide. Damages are an amount of money paid by the defendant to the plaintiff in the settlement of their claim. So it will be monetary compensation. The specific purpose of damages are to provide financial compensation to correct for financial loss incurred by the plaintiff. With injunctions, they are court orders that force the defendant to do something to benefit the plaintiff or to not do something, to stop an action. Okay? So an injunction is a court order against the losing party in a civil case that either prohibits a particular act, which is called a restrictive injunction, or compels them to perform a particular act, a mandatory injunction. And to give their specific purpose, you just need to add for the benefit of the plaintiff. So, for example, if I'm stating the specific purpose for a restrictive injunction, it's a court order against the losing party in a civil case that prohibits a particular act in order for the benefit of the plaintiff. Okay? Because injunctions cannot correct any loss that has already occurred. That's going to be a discussion point that you're going to be bringing up for questions as well. So we said the purpose of damages is to compensate the plaintiff financially for any loss or harm suffered. Okay? And the purpose of injunctions is to rectify, make right a situation caused by the person who has been found to be in the wrong. So that means with an injunction, what's a good example of a mandatory injunction? So we're a celebrity, we're suing a magazine for defamation. We're successful. What has the judge done? The judge gave us damages to help us compensate for loss of work and damage to reputation, and issued an injunction, a mandatory injunction to perform a particular act for the company to physically take down the defamatory article that they posted about us. So you can see how that helps to make the situation right. More people cannot see the article and think less of us, and it won't go around anymore. Another good mandatory injunction for that would be they have to formally issue an apology and tell their readers that they were wrong. So you will get questions in legal, usually with a stimulus, where you have to talk about a scenario and should injunctions or damages be given to the plaintiff in that situation, and why? So I've given you guys some question prompts you can read through, and these are your brainstorm points. For example, with damages, you'll be talking about how money can't fix the emotional and mental suffering and loss of quality life that the person has suffered, or it won't reverse the injury that they've ended up with, but it will cover their medical bills exactly, and it will cover their loss of earnings perfectly. So you'll be making those discussion points like this. Same for injunctions. All right, last bit of content for today is breaking down questions. So first we need to address the four parts of a question that you need to pay close attention to is the task word given in your question. You need to know exactly what a task word needs you to do. These mean different things. Content words, they tell you what section of the study design you should be specifically answering about, making sure you don't confuse concepts together. Limiting words, they tell you what not to write. For example, if a question says one example, you won't be marked past the point after one example. So if you only give short detail, you have one sentence about one example, and then you start thinking, oh, I don't have much to say about it, I'll just start using a second one. As soon as the assessor on the exam sees that you've got going into a second example, even if you detail this one perfectly well, even if you give it like perfect detail, you stop getting marked at that point and you get like, yeah, like 0 to 1 marks for that question because you chose an example that you didn't have much to say about and immediately split into a second one. Limiting words are very, very important. You need to plan your response. One thing that I will write about, because I will not get any marks past the point I start talking about something else and making sure I have enough detail. And then mark and time allocation, 1.5 minutes per mark. So we see an example with this one. Discuss. What do I need to do? Pros and cons, 4 marks. Oh, I see I get 2 marks for each responsibility of the 2 responsibilities. Okay. Limiting word 2. If I start talking about a third responsibility or include a third example, I don't get any marks for that. Past that point. Content words, legal personnel in a civil trial. Mark allocation, I've got 6 minutes for the question. Now, this is your super handy cheat sheet about some of the most common key task words. So these you will come across most commonly in legal studies, and this might be the ones where students have some issues. Discuss, you're giving for and against arguments. Evaluate, you're giving strengths and weaknesses. And evaluate is a requirement that you have an opinion slash evaluative summary. In general, for both discuss and evaluate questions, I recommend just having a little introduction statement and always having a little conclusion statement. If you get confused about at how many marks you must have an introduction and a conclusion, just do it for everything, because if you do them, it should only take you 20-30 seconds to write that introduction sentence and that conclusion sentence, and teachers like to see it as well, and examiners really like to see it. For to what extent questions, you must state the extent or you automatically lose a mark, and it's a free mark as well. For example, in your introductory statement, you'll say, to a moderate extent, this concept achieves the principles of achieves the principles of justice. To a limited extent, to a large extent, must be in your first statement. Compare questions will need you to include, and always aim for an equal amount as well of similarities and differences between concepts. Whereas distinguish is differences only, no similarities, okay? And you need to use your signposts. The first sentence you should have in a distinguish response to a distinguished question should always be the definition of the two concepts with the word whereas in the middle or on the other hand. And that's automatically already a difference between the two concepts, is just their definitions being different. And that's how you structure these questions. So while VCAT is a tribunal that blah, 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 CAV is a consumer affairs complaints body, which is blah, blah, blah. There you go, your first difference. So you should always start your distinguish question responses that way. In general, always use signposting. It's nothing worse than seeing like convoluted student responses and them like not signposting, not paragraphing, and examiners really don't like it as well. Just be very clear in your writing. You can literally overuse your signposts, and you should know many of them as well. And practice splitting your paragraphs nicely as well. Time limits, pay attention. This is do a 10 marker every week, because by the end of the year, you should be able to do a really good one in 15 minutes, even though it's a mini essay. So that's just one thing I'd address. And I've included you definitions for the most common task words and exactly what they're asking you to do. Pay attention, we've identified. It's a 1 mark question. It should take you 5 seconds. These just need you to state the thing and not discuss it. You just need to state the thing that the question is asking for. No detail, no definition. Whereas outline is giving a short definition, describe is giving a more detailed definition of a process. Explain is then one step up, because explain is just like describe, plus you have to give an example. You have to have an additional sentence and you give an example. If there's a stimulus, the example must be from the stimulus. So explain, you can see it's all layered. Identify, then outline, then describe, then explain. All of them are one step up, one thing added on. We already talked about evaluate and distinguish. I just talked about explain, how the additional feature there is you need an example. And we covered compare and discuss. Beautiful. So should be all across that, and that's already most of the questions in legal studies. We see examiners report criticism. Many questions in the exam required a discussion, but students did not discuss. It's more than an explanation. You need to consider limitations, restrictions, weaknesses, circumstance, potential reforms. Using signposting has been actually mentioned in the examiner's report as well. And the signposting can be used to demonstrate a discussion as opposed to an explanation. So it says it's an expectation for this question, for doing well at this question. Evaluate, most common issue, you see this all the time. To receive full marks for the question, students needed to evaluate 2 ways: by discussing strengths and weaknesses and provide an overall conclusion. Students not having a conclusion is being pointed out as well. So just for discuss and evaluate, just try to have an introduction statement and closing statement. Technically, if a question is 6 marks or more, you should always have introduction statement or line, and if it's a to what extent station, that will be where you say to what extent, and a conclusion statement. For 6 marks or more, anything 6 marks or more, you should have those 2 elements, because these questions will be holistically marked. And some little tips. There is a difference between a conclusion and an evaluative summary for an evaluate question. Okay? So for discuss and evaluate questions, the conclusion should be written a bit differently. Remember, discuss is about pros and cons. So let's see a conclusion. Overall, judges are crucial to ensuring a fair hearing. However, they may still suffer from subconscious bias. So this is the exact formula you need to follow. Overall, this is the main advantage of a concept, but here is the main disadvantage of the concept as well. Same formula every single time. And for evaluate, overall, judges are unable to achieve fairness in the criminal justice system, as they suffer from subconscious bias and they cannot overly help parties. So we see the difference. In an evaluate conclusion, you're fence sitting. You're choosing which side do you agree with more. Is there more strengths or weaknesses? Or is there more weaknesses than strengths? And you have to say that in your conclusion statement and say a main reason why you think that way. Perfect. It's just pointing out the importance of a conclusion, not getting full marks because you don't have it. So just always have it. 6 marks or more for a question. Oh, I need an intro, I need a conclusion. Common problems with questions. I just broke everything down. I broke down the mark allocation, the task words, linking to a case study as well we talked about earlier, especially for part B. Even if questions, this is the second half of your entire exam, even if a question doesn't say to use the stimulus, you must always use the stimulus. Because for part B, all of the questions are based on a stimulus material. So all of those 40 marks in part B need to be stimulus-based answers. That's why you need a lot of practice with it as well. So just one thing to note. Section A never has any stimulus except sometimes there's a little short answer question with a short little stimulus, but it's nice and clearly outlined that you have to use the stimulus if that's the case. And sometimes your 10 marker might have just like a little short stimulus, like a statement, a quote that you have to work with that you will need to incorporate. Beautiful. Final study tips. Um, for legal, the way that you need to study is have all the content and the knowledge first and understand it and then apply it in questions. So you never really benefit from studying if you don't sit down and do a full study and you feel like you know all the content and then you go do closed book questions without any resources. This is a really content heavy subject and you won't benefit from um, doing a bunch of questions when you don't know the content properly and it's not all in your head. So I really want to stress that first priority. What really used to help me is reading the textbook chapters that we were going to do in school before I went to class. So I would already come having some understanding of the content and then consolidate it further through the class. During class, making really good notes for myself. Succinct, based on the study design, has everything that could possibly be in legal studies questions. And the notes ended up so good that I never had to use my textbook ever again, like studying for SACs or studying for exams. And this is really good if you have a really good memory from writing things down. This technique will be really, really effective for you. And then I would revise all the content I recently learned as well, like all the different pieces of content, and do application questions every once in a while for all all of the stuff in the area of study I have learned up until then. So studying is different for everyone. You can try some techniques that might help you. Um, I just talked about what helped me studying before class, doing really good notes for myself and having everything written down for myself really helped me. And doing application like really consistently. But there are some additional things and other things you can try. Try flashcards for legal. Try doing one-page summaries. Sometimes some students before a SAC like to sit down and just do like a little brainstorm. So they think of a concept that might come up on their SAC and they try to write everything down they know about it and think might come up in a question. And when they're done, they go and check their notes and see how well they did or if they missed anything. That's something you can try. Explaining concepts to others really helps to understand the subject. Always doing timed practice questions and practice exams. And the brainstorming mind maps. It's a really good SAC revision technique and it's less boring as well. Always use your teachers to explain things though. I feel like in this subject, there's a lot of just like random points of confusion that students will have. And this subject, the most important thing is like having a good understanding of it, like we said, so you can apply the knowledge. So you need to go to your teachers and ask them questions. Make sure you keep asking until the concept fully makes sense. Even if you start to feel a bit silly at some point, like why do I still not get it? You have to keep asking. Make sure you understand the concept. And finally, try to do at least one legal 10 marker a week, because it's 10 marks out of 80 on your exam. It's a significant amount of marks. So try to get better at it. Try to get more formulaic, quick at writing them. And it's so good for content revision because 10 markers want you to put down so much content on the page about one or two concepts. All right. Thank you so much, everyone. Hope you enjoyed the lecture. And